Good morning. My name's Josh McFarland. I'm the chair of the Social Security Lawyers section of the Michigan State Bar. And on behalf of the Section Council, I want to welcome you to our February virtual seminar. We started doing a virtual seminar in February a few years ago due to COVID and decided to stick with it given the time of year and potential for travel difficulties of an in-person seminar. And considering that outside my window, there's about a foot of snow on the ground and the remnants of a significant ice storm in the southern part of our state, seems like that was an especially good idea to stick with it for this year. Now, our council is pleased to present what we hope is a fantastic slate of speakers for you today, and will hopefully help improve your practice of Social Security disability law. To start off, we have a number of speakers from SSA that are here to speak, including Doug Wynn, Regional Communications Director, and Administrative Law Judge Brian Som. He's actually the Deputy Regional Chief Administrative Law Judge. Both of these gentlemen are going to provide some remarks on SSA's current processing times, as well as hearing office updates and scheduling hearings and the dissolution of the CSUs. Next, we have a policy expert from SSA that's going to discuss some policy and procedure updates, including disability workload transfers to the Dallas DDS and some of the challenges that our members have had in contacting that office and those examiners. Then we have Hillary Hatch, Area 4 Public Affairs Specialist, and Christine Clatter, Claims Specialist at the Grand Rapids District Office, who are going to provide some updates on the local SSA offices, reminders, and some practice tips related to contacting the field office and dealing with them. After that, plan to take a short break and come back with our attorney roundtable discussion related to effective work history and function report completion, how best to go about proving migraine headache cases, and some discussion and updates related to federal court appeals. During the course of the seminar, you may have some questions. That's fine. Please go ahead and type them in the comment section. I will do my best to get to them. We do have a little bit of a delay from when we're speaking to when the stream picks up. So please bear with us on that, but I'll make sure to try to get to all of your questions and pose them to our speakers. Finally, I want to let you guys all know that we do have an in-person seminar scheduled for June 23rd in Detroit, Michigan at Aloft Detroit. It's going to be at the David Whitney building downtown. We have another great slate of speakers for that, including NASCAR President Dave Camp, Larry Rolfing, Cliff Farrell, and Sarah Bohr. We're also planning an after-seminar reception with some hors d'oeuvres and cocktails, and we also have reserved a block of Detroit Tigers tickets at Comerica Park for the game against the Minnesota Twins later that night. So it should be a pretty fun and eventful day. Hopefully you guys can join us. So please block off your calendars now. Again, that's June 23rd. That's a Friday. And so hopefully you can join us. Formal notice and registration will, of course, follow hopefully in a couple of months. So without further delay, I'll hand it over to Mr. Wynn and Judge Som. Take it away, fellas.
Thank you, Josh. Good morning, Michigan Bar. Judge Som, I think we got the wrong invitation here. So that sounds like a great agenda set for Detroit. So anyways, good morning. Good morning. It's great to be with you. And Judge Som and I have done these kinds of bar association presentations throughout the pandemic, and it's an honor, it's a pleasure for us to be here to address some of the issues and challenges, some pain points that you've experienced and you're experiencing. And we're not going to solve all the world's problems today, but hopefully Judge Som and I can at least give you a little context into what's happening. So first, I'd like to just give you a very, very high level view of the disability process and the status of where we're at right now. Well, for fiscal year 2023, we received 55% of the increase that the president requested for SSA's administrative budget. We're thankful for the funding increase we received from Congress. We'll use these resources as best as we can to mitigate further service deterioration. We know that one of our most urgent service issues is the significant number of people who are just waiting too long for a disability decision. And we all know that. We've got to address the significant number of people who are waiting too long. In particular, we share your clients' frustration about waiting over 7 months on average for an initial disability decision. We're confronting historically high employee losses, especially in the DDSs that make the medical determination for initial disability claims and reconsiderations and conduct medical CDRs. So just give you a little perspective, the initial disability claims pending level soared to almost 975,000 cases at the end of December 2022. 975,000 pending cases. That's more than 380,000 cases. That's higher than at the end of FY 2019. Okay, the average initial claims wait times through December 2022 was 206 days compared to 120 days in FY 2019. So you can see everything is just doubling. And what SSA is doing, we are taking a comprehensive, multi-pronged approach to reducing the backlog of disability cases that developed during the pandemic. This strategy includes immediate action using specialized teams of current and recently retired SSA employees with disability experience to assist the state's disability termination services in processing cases, helping the state, the feds were helping the states to recruit and retain employees in order to address processing capacity issues in the DDSs, and a thorough review of the disability process to promote efficiency and consistency. We've already begun to implement these initiatives to improve service to the people who are counting on us. And but it's going to require adequate and sustained funding year over year for us to accomplish these goals. And it's going to be more painful in the short term before it gets better. You probably already read in the news. I mean, people can expect to wait a little bit longer on our phone lines. It's going to take a little bit longer to process some cases. And we're analyzing factors that are contributing to the backlogs to reduce it and to prevent a recurrence. There are a combination of complex issues, including difficulty hiring, similar to the larger labor market. We've got historically high attrition in the DDSs, about 20% in the last 2 years for disability examiners turning over. We're assessing for the drivers and shortages of medical experts to conduct CEs and to review cases. So these are not simple solutions. And again, it's going to take a multi-year effort, sustained funding from Congress to restore our average initial disability claims waiting times to pre-pandemic levels. Again, that's probably not what you wanted to hear from me, but that's the status of where we're at right now with the budget that we have right now. Hopefully, you all received, yesterday we sent out a Dear Colleague letter, and Judge Sami may have something more to say about it, but we announced a new centralized mail process for hearings operations. It's a streamlined method for processing paper mail sent to the hearing office. You can now use the unique post office box for each hearing office where all incoming mail will be scanned by a contractor. The scanned documents that include the barcode cover sheet uploads automatically to the hearing case files and are immediately available for our staff to take appropriate action. So this centralized mail process is going to enhance customer experience at the hearings level by improving the speed and efficiency of processing paper mail. So we're doing what we can do, in areas that we can do certain things. And so I'm going to stop there, let Judge Sami take the rest of my time, and then we'll we'll talk about the DDS the DDS work transfers is one of our is part of our multi-pronged approach to working down the disability backlogs. And I'll let Sonia Ross, our disability program administrator, address that. So the floor is yours, Judge.
All right, thanks, Doug. Yep, and again, I'm Brian Sami. I'm the Assistant Regional Chief Judge for the Chicago region, also the Hearing Office Chief Judge in Chicago. I appreciate the intro and what you said, Doug. I don't have anything particular to say about the mailers or the mailing that went out about the centralized mail, other than we are really optimistic in the Hearing Office that this will free up resources so we can spend more time working on developments for claimants, working up the files, making sure cases are ready to go, both pre-post hearing. So knocking on wood that this turns out to be a good thing, and I hope that it's beneficial for you all. So with that, I have a number of talking points related to scheduling for hearing officers and just some general reminders. Now, keep in mind, these are going to be pretty overbroad, I guess, or not getting into the weeds, and certainly not addressing any of the specifics. I know there was some discussion before we officially started here related to issues with the transition from CSUs back to scheduling in the hearing offices. When we get to the Q&A session towards the end of this, if you have issues, I probably can't address anything or solve any problems right away, but I'm very happy to take back feedback or issues that you have so we can try to address it. With that, okay, so you probably all know hearing offices took over scheduling effective February 1st, 2023. And by the end of February, the regional CSUs are going to be dissolved. There will not be any change, however, to where and how reps submit availability for now. You will continue to submit your availability to the RCSU email boxes. I know that seems weird, and I double checked to make sure that even though we're dissolving the RCSUs, this is the right place to go. It is. The regional office will continue to consolidate this availability and make it available to hearing offices to use while scheduling. So, as of January 1st, 2023, there has been a change to when you must submit availability. In December and January, we began to request rep availability using a national consistent due date. Starting in January, all representative availability is due to the RCSU rep availability email boxes on the 1st of the month, 5 months prior to the start of the month, to be scheduled. That means, for instance, that availability for June was due January 1st, availability for July, February 1st, and obviously availability for August due March 1st. We have been sending email reminders to reps with the new due dates, and hopefully soon you will be hearing about an enhanced method for the ability to provide your schedule for hearings. So please stay tuned for some future communications from OHO regarding rep availability. Some general scheduling and reminders info. Our offices generally schedule cases in a first in, first out method, as you probably know, with older cases having a hearing first. We do continue to triage cases requiring expedited processing following our continued approach to dynamic workload management outlined in our National CARES, Compassionate and Responsive Service Plan, and critical cases reflected in HALEX. All initial hearings are scheduled at least 75 days out. When necessary to schedule an initial hearing less than 75 days out, we will contact you to ask whether your claimant is willing to waive the right to advance notice of hearing. Please do not email personally identifiable information, PII, or postponement requests to the rep availability mailbox. If you do have a request, like a postponement request, or you need to contact the office regarding a particular case, please contact a member of the hearing office management team. If you know who the hearing office or the hearings, it's the I'm forgetting the acronym. It's the HOC, the hearing office coordinator. You can reach out to them generally, but anybody on the management team, and just send an email with the date, location, and ALJ hearing the case. With that, we can find the claimant information for your particular case. Okay, then I just want to go over briefly some COVID-19 remote hearing agreement form reminders. soon after cases are received by the hearing office, we do send out COVID-19 remote hearing agreement forms. This form asks claimant and/or rep whether the claimant consents to a remote hearing modality, either telephone or online video hearing, or both. It is really critical that you guys get this form back to us as soon as possible. We are not scheduling remote modality cases if we do not have claimant consent for those modalities prior to scheduling the case. If we do not receive the COVID-19 remote hearing agreement form within 3 weeks after sending it, we will try 2 times to contact the rep to discuss consent for remote modalities. As part of the acknowledgement of the request for hearing, we also provide notice of an opportunity to object to traditional video teleconferencing hearings within 30 days of the receipt of the notice. If we don't receive a response to the COVID-19 remote hearing agreement form or to subsequent outreach, we won't know to schedule the case as a telephone or OVH hearing. So without affirmative consent prior to scheduling the hearing, we will schedule the hearing as in-person or as a VTC hearing if applicable, and if there is no timely objection to VTC. We often begin selecting cases to schedule very soon after we receive the case in the hearing office, so it really is important that you return the COVID-19 remote hearing agreement form as soon as possible. And just a best practice tip, really good idea for you to discuss the modalities with the claimant at the time to request that the request for hearing is filed. This way, you'll be prepared to fill out the forms consistent with claimant's modality choice as soon as the representative receives the form. With that, that's my prepared talking points. Again, I'll turn it back over to Doug to pass on to the next speaker, but happy to at least take any feedback and hear any complaints about, the transition. I know it's going to be rough, but hopefully bear with us and it will smooth out. Thanks, Doug.
Doug,
Myself, let me take myself off mute. Yeah, next on the agenda, and we'll take some Q&As after Sonia gets done, but she'll talk about the DDS transfers and how to best contact the DDS at this challenging time. Go ahead, Sonia.
Good morning, everyone, and thank you, Doug. Again, my name is Sonia Ross. I'm the Disability Programs Administrator for the state of Michigan. So I work closely with the Michigan DDSs and field offices. The topic that you guys asked me to address is the assistance that the Michigan DDS is receiving from the Dallas DPU. Basically, based fiscal year 21 and 22, the Michigan DDS was inundated with a lot of claims receipts, as Doug talked about. Simultaneously, at the same time, there was significant attrition in the DDS. And what that created was more cases that were received that we could not handle in Michigan. And we sought assistance from other entities to help with those workloads. We did have an alignment with the Dallas DPU, and they have been assisting us working down the cases that were transferred to them. In fiscal year 23, we discontinued sending cases. We have been able to do some level of hiring in the Michigan DDS, and for fiscal year 23, we expect to bring on an additional 80 positions in the DDS. As you can expect with new hires, it's going to be a while before they are proficient as the folks who had left. So we're still going to be in this period of time where we're going to be really looking to balance workloads. Specifically about the assistance, I understand that you guys have received some concerns about inability to communicate with the Dallas DPU. We are working with our Dallas partner to kind of work to improve in those areas. Like the judge mentioned, I'm definitely open to taking back some feedback. The preferred method of communication with that unit is with the examiner that has the case assigned to them. So the information that you received when you are communicating with the examiner there is the preferred method. If there is an instance of some significant change regarding the applicant, dire need, or some priority handling, it is the expectation that those would be able to be addressed using our normal procedures for addressing or expediting. What we want you to our main message is that we want you to reach out to the specialist. If there is those challenges where you're not seeing responses, we would like to hear about those. Like I said, the Dallas DPU is working on streamlining communications, making sure that they are providing responses timely. A challenge for them is they are not only working Michigan cases, but they also were a release valve for other states. And so just making sure that they're balancing the attention towards all of the different workloads that they have. Again, as the judge mentioned, I am here to hear of any specific challenges that you have, and we will continue to work with our Dallas partner to try to address those as they arise.
Thank you very much. Thank you very much, Sonia. And then, last person we have to address in terms of touch points with SSA, contacting SSA, various methods, service options. Turn it over to Hillary Hatch, our public affairs specialist over at Grand Rapids. And Christine Clatter, by the way, also works directly in the Grand Rapids office. She was also one of my former public affairs specialist detailees over there, and she's just a great technician all around, and is a great resource for all of you there in the Grand Rapids area. Go ahead, Hillary.
Thank you. Good morning, everyone. Thanks, Doug. And I have to echo what Doug said in regards to Christine. She really is one of our technical experts that's going to be talking to us today. So I'm going to go ahead and share my screen. I have a PowerPoint presentation. It's not very lengthy, though. So let me bring that up. Okay, can everyone see my PowerPoint?
Yep.
Awesome. So like I said, Christine and I, we really have a short agenda for you today. We just want to give you some brief updates and just provide some insight on what's happening in the field that will hopefully assist you. We're going to be talking about the redesigned website, the new centralized mail process that Doug mentioned earlier, online application reminders, some reminders and some tips about that increase in the fee agreement. Christine's going to talk about some of the things that she's been seeing in the field. Also, my Social Security accounts and the medical continuing disability review online that is now available. So we have a new look and feel to our website, ssa.gov, and the idea behind this is really to make the website more task-oriented by breaking it down into 3 main tasks right on our homepage. So of course, there's prepare to file for benefits, applying for benefits, and then also to manage benefits. So that's the top of the homepage. And then the bottom of the homepage is where you're going to find the link for services for representatives. And for most of you, this is probably where all that good stuff is going to be. You can see the link right there. That will bring you to this next page here. So this is where you're going to be able to submit the electronic 1696, the electronic 1693. The very bottom arrow is pointing out where to subscribe to receive updates from Social Security. So you can choose how frequently you want to receive those updates, whether it's daily, weekly, monthly. And then the arrow right above that one, that is the link to resources, fact sheets, and guides. And this includes tips and best practices for reps, electronic records express, processing center telephone contacts, and a lot more information that may be helpful to all of you. So I know Doug talked about this briefly in his introduction, and it's the Social Security's, the Office of Hearings. We just announced yesterday the new centralized mail process. So this is a streamlined method for processing paper mail sent to hearing offices. So you now have a unique post office box for each hearing office where all incoming mail will be scanned. Those scanned documents that include a barcode cover sheet upload automatically to the hearing case files and are immediately available for our staff to take appropriate action. And the centralized mail process, it's really going to enhance customer experience at the hearing level by improving the speed and efficiency of processing that paper mail. So we began implementing this initiative across OHO this month. We have helpful information available for appointed representatives as we implement this initiative in the Office of Hearing Operations. So for cases with an electronic folder, continue to use the Appointed Representative Services, or ARS, to upload documents to the electronic folder. When sending paper mail to a hearing office's unique post office box, always include the claimant's barcode cover sheet that was included with the acknowledgement letter as the first page. The scanner will use that barcode cover sheet to associate the sent mail to the appropriate section of the electronic folder. When the barcode cover sheet is unavailable, make sure to include the claimant's identifying information so the office can associate the documents with the correct claim. So for cases with an electronic folder, send all mail for cases pending at the hearing level to the for cases without the electronic folder, make sure to send all mail for cases pending at the hearing level to that unique post office code for the specific hearing office. And on the next slide here, it shows on our webpage what that will look like. So at ssa.gov/appeals, you can click on locate a hearing office, and that's where you're going to be able to find that post office box, that mailing address to send that information in. So I'm going to bring you back to what that homepage looks like, where individuals will get started with the application process. And this is where Christine will take over with some application reminders.
Good morning. How is everybody today? We're glad to be here. As Hillary said, our biggest thing is using our online portal for our claimants. There's so much out there that we can do online, that the claimants can do online. And the biggest thing that we've been seeing in the local offices is we get online applications submitted from third parties, but they're not signed. And it takes 3 to 6 months before we actually get the signed application in, which then delays the disability process. So, the biggest thing we're looking for is getting that signed application to us, getting that SSA 827 into us so that we can start that disability process and get it down to our examiners as soon as possible. So recently this year, there's a change in the fee amount that representatives are getting, and I know that there's been a little bit of hiccups with that. So my recommendation would just be to reach out to the local office if there's an issue, if they didn't pay you the amount or something got missed, because it happens. So we just ask that you help us and we can help you and that kind of stuff. But we do know that the increase did come from the cap of 6,000 to the 7,200. So we are working on making sure everybody's up to speed on that and getting that so that we don't have any hiccups with paying the appropriate amount that's due to the representatives. So the My Social Security account, you can do so much in here. So we recommend to all of our claimants, that they utilize it, that they have one, that they have an account set up. So that way down the road, they can use it for so many different things. They update it constantly. There's so many things that they change regularly to be able to have easier access for our claimants to better communicate with us or get some stuff submitted to us, that kind of stuff. So if they have a My Social Security account, that's huge. And we always recommend that everybody has one. They can request. Go ahead.
Sorry, Christine, I just wanted to say, I always joke that it's not a true Social Security presentation unless we talk about the services available online and through my Social Security accounts. And just as a reminder, you can assist individuals with creating the account, but you cannot do that for them. And like Christine said, it's really great for individuals, whether they are receiving benefits or not receiving benefits. If they are not receiving benefits, they can receive a replacement card online. They can get estimates of their benefit amounts, check the status of their application or appeal, and they can also get a copy of their electronic folder sent to them. If they are receiving benefits, they too can request a replacement Social Security card online. They can report wages, they can print benefit verification letters, update contact information. You know, they really can do business online without having to call or go into the local office. And like Christine said, we are continuously working to improve our efforts to serve the public, especially through our online services. And we recently, just this month, I believe, rolled out the newest application available through my Social Security, and that is the online medical CDR form. So I'm going to turn it back over to Christine, and she's going to talk about this.
So this is fairly new, which we love in the local office because we get a lot of continuing disability reports that are paper that we have to input. So for the representatives, this is like another reason to push your clients into maybe looking into getting that online account, because once they have an online account, they can submit their continuing disability review reports to us online now. And it comes right through electronically. I actually saw this in real time the other day, and it was amazing to see because we're not waiting for the mail to come through and somebody to input it. We actually have access to it like instantly. So they pull them in daily. And so now they can actually submit these continuing disability reports online, along with the 827 that we need. And then they can, we can access that immediately. So there's no hiccup in their benefits continuing while this medical review is ongoing.
So that's all that we have for our slides. I will turn it back over to Josh.
All right, thank you guys. A lot of good info there, and obviously we've got a whole bunch of questions here, so I'll try to get through them here. The first, we've had some comments and some questions about this. Has there been any, given the backlogs that they have with DDS and reconsideration and things like that, and obviously the turnover that you mentioned, has there been any consideration in getting rid of the reconsideration stage? I mean, we brought that back, and that seems to have increased the backlog, maybe helped the hearing offices a little bit, but definitely has slowed processes down pre-hearing. Is there any talk of that, getting rid of that again?
Not that I'm aware of, Judge. It's way over our pay grade, Josh.
Yeah, I figured. Now, there's also something that I've noticed with my clients as well. They can log into the My Social Security account and see, it seems like they have like a little bit of a percentage calculator as to how far they're through the process, and it'll tell them, we're 50% through or we're 95% through. I've seen, some of my clients have said, I've been stuck on 95% for like 5 months. I'm assuming that that's not an exact science, and that's what I've been telling my clients, but obviously their frustration with that, thinking that they're so close to determination and then waiting, the 5 months for them to get that other 5%. Is there anything that we should be doing or telling them as far as that? Is there anything that they need to do when it gets to that point? Because sometimes they're a little paranoid that maybe there's something that SSA is waiting on from them that they're not getting.
Christine, you want to take that one?
Sure. So if there's I guess I would say a delay. So if they're at 95% for a given amount of time, it doesn't hurt to contact the local office. We can take a look at that and see what's going on, see if by chance it's just one little thing that we're missing, or if We see a lot of them where like the examiners have been trying to get some information from them and they haven't responded. And we can point them in the right direction to their examiner. So it doesn't hurt for them to reach out to the field office directly to find out like what the holdup is, or if there's something that we're waiting on that we just haven't gotten yet. So that way we can push that case to that full 100%.
Okay, excellent. One of the other questions we've had is, and this kind of relates to the turnover and a change in the disability examiner, notices that either go out to the rep or the claimant, or preferably both, giving notice of who the examiner is and their contact information. We had one comment here that they would get the initial one, they'd contact the person, have a line of communication with them, and then one day they call it and said the number is no longer working, line's been disconnected, but they didn't receive any new notification of who the new examiner assigned to the file is. What should we do in that situation?
Hey, Sonia, you want to give that one a try?
Sure. Yeah, I can't be sure if that's just a case of maybe some of that attrition that has occurred. That's why that number is no longer working. I would say if you run into that issue, what I would say is to see if you can reach out to the field office. They could look to see if that case is still assigned to someone else, or they could direct a message so that we can follow up appropriately.
If I could just address that real fast, Josh. I mean, one of the problems I have seen is that the field office doesn't seem to have much more access to figuring things out than we do. And I will call the field office, especially when there's been a delay, to find out who the examiner is, and they often can't figure it out either. And getting an answer from DDS at just the general information number is very difficult. They will not normally tell us who the examiner is. They won't put us through to them, and we have to send them a fax just to get that information, when a quick 30-second lookup and we'd be on to the right examiner. So that's something that DDS really needs to address, is getting that information out to us and timely. And we do understand the attrition and stuff, but it makes it very hard for us to do our jobs, especially when the field offices really can't even help us.
If I could just extrapolate on that. One of the things I have had success with is at least in the Kalamazoo DDS is when I've run into this and I haven't been able to make contact, I've asked to speak with a supervisor of the examiner assigned the claim, because I've ran into this a number of times where the examiner no longer works there, or they're out on like a 12-week leave for personal reasons or whatever, and the file's just sitting there, and I'd bring it to the supervisor's attention and it gets reassigned and what needs to be done. But I do think, as far as bringing feedback for the DDS offices, I think some sort of policy about immediately sending out a notice when there's a transition of the file to a new examiner should be a policy that should go out within like 2 weeks or something when there's a new examiner assigned. That way we can do our job and help DDS do theirs.
It's a good suggestion, Sonia, right?
Yeah, I'm making a note of that, and I do appreciate the feedback, and the proceeding to the supervisor, I think, would be an appropriate step. I do hear the other comment when it's not really readily known who the supervisor is, and also looking to see how we can address providing some information on that. So thank you for those feedback.
Also, is there any way to bypass all of those initial messages when you call the local office and the field office? It seems like my phone calls are like 3 minutes long because 2 minutes of it is listening to messages.
Josh, that's about true of any entity that you call now, right? Whether it's your cable company or your doctor's office, you got to go through this whole litany of menu items, right?
Yeah, I don't know if it's the menu items. I think it's more of the, the disclaimers that they have at the beginning about COVID, and then they have another one, and you just can't skip through it.
Just like the disclaimer that Hillary and Christine put up at that last slide.
Yeah. All right. We have another comment and question here. you've had situations where DDS examiners will not speak to me, even though I have filed a 1696 with the local SSA field office. Who confirms that I'm listed as rep on the case, and any guidance when you get this disconnect between the local office recognizing your appointment of rep and DDS not recognizing that?
I don't know if
Christine,
you guys want
Sonia.
to talk about it in the field, how it starts in the field.
Yeah,
Well,
I guess
I'm not with SSA, but I might have some of the answer here because I've dealt with this a lot on cases. Is that at the field office level, our rep documents have to be put into the case manager and into Razor. And if they don't do both, then you will not show up with DDS. And so DDS will not talk to you until that is. I can't tell you how many times I've had to call field offices and find out that we weren't put into Razor as the attorneys of rep. And so if you're having that problem, that's your first step. Now, the second step is somebody needs to address with the field offices why they aren't doing that on a regular basis. It's part of the procedure they're supposed to follow. And, you know, anonymously and behind closed doors on the phone, I have been told that there are a lot of field office employees that they are trying to get cases off their desk, and that's an easy step to skip. So take it for what it's worth, but reps out there, that's how you make sure you get into the system. Make sure you are in Razor.
Christine, you have anything to add?
So, I mean, yeah, it doesn't hurt to reach out to the local offices because we do know that that's how reps get their access to the electronic files nowadays. And so it is very important that we do add them. But if you are having an ongoing issue, please feel free to reach out to us and we would be able to address that. But yes, we do start it at the local office, we add you, and then we upload the documents into the claimant's file, which then gives DDS access to know that you are the appointed representative for that claimant.
excellent. There was also a question here. This is related to the My SSA accounts and applications online. There's a number of people that we represent that they just can't do it online. You know, either they're elderly or for whatever reason, maybe their disability itself does not allow them to do that, or they just don't have access. Are they now? I think they're able to apply in person now at the local offices. Are they also able to process applications over the phone as well for those individuals?
Go ahead, Hillary.
We don't process that over the telephone, but if they are in the office, we definitely can set up a My Social Security account for them. So my advice would be, if you're talking to one of your clients and they have to go to the office for any reason at all, I would suggest to them, hey, while you're there, why don't you set up that My Social Security account? Because it would probably be easier for them to do it, you know, right while they're in the office instead of trying to do it online at home.
That Josh, by doing it in the office, they skip over a couple of, you know, other authentication, you know, the authentication steps that you have to go through when you're at home. So it's much more efficient, much more quicker at the office.
Yeah. Now, are you guys, I think previously, you used to be able to kind of like make an appointment to come into the office so that way they don't have to worry about maybe waiting in a long line to do it. Is that still an option for them?
Oh yeah, we highly encourage making an appointment before you come in, but we're obligated to serve anybody who walks through the door.
Sure.
So.
Okay.
So Josh, I can throw in a question here.
Yeah.
And we talked about this as was discussed earlier about the new CSU going away and the new scheduling problems and things like that. And I guess it would be nice to hear what SSA is doing to resolve the scheduling problems that are happening. From my perspective, it kind of looks like the Old West has been released and the hearing offices don't really understand the scheduling process very well. They're seemingly very overwhelmed with trying to figure out who has an available slot and where they can put them in. We're getting a lot of conflicts. And just as a personal aside, before you guys address that, I don't think it's appropriate for attorneys to be asking judges to adjourn their cases because SSA made a scheduling error. And it's highly affronting to me to have a letter that comes in that says your adjournment request was granted when I didn't ask for an adjournment. I asked for SSA to, fix the scheduling problems that they created, because then you're putting us in a position where our clients are suddenly saying, why did you ask for an adjournment? Or our bosses are saying, why didn't we assign this to somebody else? It creates all sorts of problems on our end, trying to effectively represent our clients who are already suspicious of attorneys and are already suspicious of the government and conspiracies and all those things. So I'll stop talking for a minute. And I know you can't talk about it a lot, but it would be nice to know what's being done to sort of, deal with these issues.
I'll punt that one to Judge Sami.
Yeah, I appreciate it. I guess what we need right now, I've already relayed some of the comments you made before we started officially to our regional management officer. What we'll need to do is work with those offices. And again, here's what I'd say. One, if you have an issue with your scheduling, contact the hearing office coordinator as soon as possible, or at least a member of the management team in that hearing office to alert somebody as soon as possible. I'm not saying that that's what the solution should be. What we'll do is we'll try and work on this so you don't have to do that in the first instance. So what it sounds like we need to do is go back to at least the Detroit Metro offices, maybe more, just a general reminder perhaps to our offices of the procedures they are supposed to be following to ensure that these things don't happen. So I appreciate that you're experiencing some difficulties. I agree. You shouldn't be forced into the Hobson's choice of either scrambling to find coverage in a conflict versus having a hearing postponed, especially for someone who's been waiting a while. And that puts you in a tough spot of explaining to your client, why does it happen? And perhaps trying to explain this isn't your doing. If I would just encourage you, please reach out. If you continue to have issues, reach out to our regional office and let them know of sort of systemic issues that you continue to see. But I hope that this is a short-term hiccup rather than the start of long-term systemic issues with the scheduling.
Judge, if I could jump in just real fast.
Sure, please.
Is it possible for us to get a list of who the individual hearing office coordinators are for scheduling? We seem to kind of find them randomly. I know that when CSU was around, we knew who the contacts were from time to time of who was in charge of those programs. For example, I know who the Lansing, Michigan OHO person is because I've talked to her before and she's now in charge of it. But it would be nice to know who that person is so that we can at least email them with the problems, potentially phone call, a problem, and disseminating a list of that. And quite frankly, nationwide disseminating a list of that. It's not going to make your OHO coordinators happy, but it would really help us to know who we need to talk to.
Yeah, I'm checking. Again, I just sent an IM to our regional management officer. If we can do it, if there aren't any other sort of concerns in releasing that information, I'd like to do that. I'm guessing at least some of you here practice elsewhere in Region 5. I can't speak for other regions or nationally releasing such a thing, but if we can do it for Region 5, it might be something we could transmit at least the hearing office coordinators for the Region 5 hearing offices. Maybe we can follow, if we can do it, maybe we can follow up and get that information to you all after. Good idea. I think that's a good idea. I think that would be a nice contact reference list. Understanding that at the time we release it, within a week, it might be stale for one or two offices, but at least you'll have a place to start, right? And at the very least, you can, in those offices where you can't get a hold of that person, hopefully it'll get to someone who you can talk to.
Yeah.
Hey, Josh. Jumping back to the application, in those situations, and this might be for Christine and Hillary, in these situations where we're assisting a client that completes an online application, and for whatever reason they can't get into their My Social Security account, either they got their password wrong so many times or whatever it is, and we help them online and submit it. And then we mail in our paperwork, our rep paperwork, or we submit our rep paperwork to the field office. Is there any way we can expedite the process rather than having to wait, a week or two for the application to get mailed to the client for them to review and sign and mail back in? Can we print off the application, that the receipt that we get, and have them sign it and send that in? Or can they make a phone call to orally attest to the fact that they completed the application later that day? Is it something like that we can do?
So I do know that there is a 3 to 5 or 3-day business hold on a lot of our online stuff that comes through. And so that's why there's kind of a delay with stuff that comes through. We do like to have the claimants get their applications, review what was submitted to us so that we make sure that they know what was submitted. Take a look at it. That's why we do mail it out that way and have them review the entire packet and send it back to us. It does take a little bit of time and nothing happens just overnight. So there is sort of a delay. But my recommendation is if they haven't received it within, 14 days, to contact the office, because it usually goes out within a couple of days to the claimant to sign, review, and send back to us. But what we've been seeing is we get cases and it takes 5-6 months for them to sign it and get it back to us. And it could have been that they mailed it to us and we never got it. I don't know, but it doesn't hurt to follow up if they haven't heard anything within, 3 or 4 weeks or whatever of what's going on.
Okay. Thank you.
I have a question about the PO boxes you mentioned earlier for the mailing things to the hearing office. They each have their own PO box. Should we be sending the fee petitions in cases? Should we be sending them to the PO box or sending them to the address for the hearing office?
You want to take that one, Hillary?
I don't want to take that one because I'm not sure.
Yeah, we'll look into it. We'll get back with you, Josh.
Yeah,
Okay.
I wrote that question down and I'll follow up with you afterwards through email.
Sure. All right. All right. Now, we also have some people commenting that they've been having problems filing appeals online. After entering all the information, they're getting an error message that says the process cannot be completed at this time. First off would be, are you aware of the issue? And if so, what can we do to rectify that, or who do we contact when we run into that problem? And somebody else mentioned that it might be related to something with regard to uploading documents, and that might be why they're getting that error message.
So, Josh, I'm going to take this opportunity to pitch an upcoming technical training that Hillary and my other public affairs specialists around the region are about to do. We're implementing, we're rolling out a training package for appointed representatives. It's going to cover the I-appeals. It's going to cover the other forms. And some of it is, a lot of it's going to be basic to this group here, but we'd appreciate if you guys can hop onto that training. Hillary's going to send out more details as we put the training package together. Again, it's going to go through the steps in the I-appeals with you, what you're experiencing in terms of uploading forms, and even, we're seeing, forms even coming back with, unauthorized signatures or no signatures. And so we want to go over those reminders with all the appointed representatives on a separate training package that Hillary's going to roll out. So if we can just hold on to that, because that's going to be a longer discussion than the 2-3 minutes that we've got here. Okay, Josh, promise, we're going to address it. So Hillary, you can make a note of that for your training package, and she's gonna circle back with you, and if you can send that invitation out to as many of your appointed representatives, legal representatives, non-legal representatives, that'll help us out in getting the training information into the right hands. Thanks for that question, though. It was good.
Yeah. Excellent.
I do think, though, that doesn't really address the question that was asked, though, which is, are there technology problems that are happening that are causing this, or is it user error? Again, the people that are sitting in on the seminar today are going to be a wide range of people that have done this for, the electronic stuff for as long as it's been around to fairly new at it. I'm not sure that it's really user error on our end most of the time. I mean, there was a period a few months ago that we were having difficulties getting into ERE through the ARS, but, that has seemingly resolved now. Does this seem like it's a technology error, or does this seem like it's a user error when we're getting these messages that more than one person is getting?
Yeah, Sonia, when you talk about technology, it's another can of worms that we could, I know that we've got a IT systems modernization effort that's intent on making benefits claim systems more accessible online. I'm not going to sit here and try to pinpoint whether it's user error. Some of it could be user error. Some of it could be part of our systems modernization business process that we're trying to work out the kinks on. Just know that is a work in progress. I don't know, Sonia, if you have any further insights into the systems modernization efforts, but go ahead.
The only thing
Go
that
ahead.
I was going to contribute to that is obviously I can't really speak to the specific outages that you guys were referencing, but there are from time to time some maybe temporary outages, and maybe that could be attributed to why it did not it did not connect. I think we would need to have more information about it. If you're reporting that this is a widespread, from Friday to Sunday, there would be something more concrete that we could look into regarding that. So if there was that type of feedback, I think the one-offs may be just an anomaly or something like that. But if there is something more concrete that you do have, enough of your users who are reporting it, I think that would be something that we want to hear about so that we can look into the issue a little bit further.
Who should they notify of that, or is there a tech support line or something like that? I know for ERE there's a tech support line, but maybe not for the I-appeals.
Yeah, I do believe
Hey,
there is some support, but hey,
Eric, my deputy is also on the line. You want to jump in, Eric?
Certainly, I appreciate that, and I apologize for not being on camera here. I'm actually in travel at this moment here, but I do want to say that this issue has come up as the regional ombudsman for the Chicago area here. We do get a lot of cases, a lot of requests for assistance from our attorneys here. One of those I do recall has been this issue. It was sent to our systems, but one of the things that we do need in order for us to go ahead and further troubleshoot this issue is we need the actual SSNs for these cases. So I will make that plea. If you do have cases that you're running into, please send us the exact Social Security number for our folks, our Office of Electronic Services, to go ahead and review and troubleshoot on their end. And they're in our central office location. But again, without these SSNs and without detailed information, where there's no way that they can troubleshoot that further. But I do ask, send them into us as you would as your regional ombudsmen. Send them to us so that we can go ahead and further look into that. But again, this is something that was brought to the attention of the Center for Systems and Automation, and they are still looking into.
Yeah, so that's a good question, Greg. So yeah, and thanks for the reminder, Eric. Yeah, you're right. We have received a couple of those systems issues related inquiries. I just forgot.
And so specifically though, who would we contact? Like what?
Send them to me. Send them to my office, chi.rpa@ssa.gov, Josh and Greg. So chi.rp as in public a@ssa.gov. I'm talking specifically about those couple of systems related glitches.
Okay.
And then we'll share it with Sonia too if it's something a little bit more systemic.
Excellent. All right. I think that's all the questions I see on here. So
Talking
thank
about
you all.
perfect timing.
Yeah.
Perfect timing. 10 o'clock.
So we'll take a short break and thank you all from SSA for joining us here this morning. Provided a lot of useful information for our members. And obviously, I'm sure you're going to be receiving some follow-up emails and things like that. So hopefully you can help anybody out with any specific issues that they have. But thank you, guys. We're going to take I don't know, probably short, we'll call it a 5-minute break. Allow people to use the restroom, refresh, get up, stretch around a little bit. And then we'll come back at about 10:05.
Thank you all. Thank you, Judge. Thank you, Hillary, Christine, Sonia. Bye-bye.
All right, thank you. Take care, everyone.
You as well.
Are we offline?
We've lost all our diversity. And nothing left but old white guys.
I think the stream is going to stay up, but
Okay, we're not live anymore, right?
no, I think we are. I think the stream's going to stay up. I don't know. There's a way to pause it.
Okay, I'll be right back then.
Yep. All right. So welcome back, everybody. Now we're going to move into kind of more of an attorney roundtable discussion. We got a number of topics to cover here. And again, just keep those questions coming if you have anything. Usually the attorney roundtable discussion can be some of the more useful information, and we get a lot of feedback on those. So we like to have these if we can every once in a while to provide some kind of perspective from what other attorneys are going through, and try to see if we can come up with solutions together to address those. So we're going to start off with a federal court update from Tom. Tom's a seasoned SSA litigator in federal court as well as at the administrative level. So we'll let him kind of provide us with some updates as to what's going on in federal court. And in particular, I think some of us, myself included, interested in the new and latest service of process issues, or I guess procedures, not really issues yet, that we have to go through now.
Thank you, Josh. Yeah, I'm Tom Gilhut. I practice out of Grand Rapids. And my impression is there are a lot of lawyers that don't do federal court. So I'll quick make a pitch that it's a good idea to learn how to do these. It will make you a better Social Security lawyer at the hearing level if you do federal court work. When you have to defend what you did in front of the ALJ to a federal court judge when there's a U.S. attorney throwing rocks at you, it makes you think about what you're doing at the administrative level, and you learn what the courts are looking for. It's a little bit different from what Social Security is looking for, so you can have your case prepared for that potential appeal. And federal court is a good learning experience. I think the two things you can do to improve your practice the most are, one, if you're new to this, go to a NOSCR seminar, one of their national seminars. You'll learn a lot. And number two, start doing federal court cases, because you'll learn your mistakes, and it'll improve your practice. The biggest change, well, the state seminars are good too. The biggest change in the federal court recently was a change to the court rules on processing Social Security appeals in federal court. These went into effect December 1 of last year. So we've only got a couple months of experience in these. And a lot of it is procedural. One of the biggest parts of it is the way that once you file your complaint, it gets served on the government and what happens after that. It used to be you had to get summonses issued, and then either you would serve the summonses, and there would be 3 summonses that you'd have to serve the local U.S. attorney, you'd have to serve the Social Security Administration, and you have to serve the General Counsel's office. And those kind of moved around, and it was always kind of a pain to keep track of those. Now, if your client was unable to afford the cost of litigation, you can get a motion to waive those costs, and then the U.S. Marshal would take care of service for you. But you'd still have to follow up on them, because they didn't always get the paperwork processed, and then that would trigger, once it was served, that would trigger you have to report that back to the court, and then that would trigger the time for them to file an answer. And it's just sort of usual lawsuit stuff that we've all done if you're doing any litigation, but it's simpler now. And once you file the complaint, then the clerk's office takes care of sending it to the U.S. attorney. And you don't have to keep track of those things. And then the government doesn't have to file an answer. They just have to file the administrative record, which includes a transcript of the hearing and all the exhibits from the hearing file. So it makes it a little simpler, a little less expensive, because you don't have to pay for service. And so it's working well. I filed 2 cases, one right before December 1. I had to still do it under the old rules. I was like, November 28. I couldn't wait a couple more days to do it under the new rules. I had to file it. But I have filed one since then, and I talked with the U.S. attorney with the clerk's office last month about how that's going. And this is in the Western District, and they said it's going fine, that they're able to get those out to the U.S. Attorney's Office. And in the case that we did, we received the administrative records, and so we've gotten the scheduling order, and it's moving along. And so it's not a big change in the Western District because it's very similar to what we did before as far as the scheduling. The service is different, but yeah, it's just simpler. In the Eastern District, we used to have to do motions for summary disposition that are not required anymore. The Western District or the Eastern District hasn't issued any new rules, no local rules about processing this, because this rule is part of the rules of federal appellate procedure. So, or federal procedure, and so they didn't feel like they had to issue any new rules. They're just following the rules, and so yeah, nothing dramatic has happened yet that I've heard about in Michigan as far as the new rules, but it's still fairly new. You know, one thing that there's kind of a landmine in there is that the deadlines for filing briefs are tied to events. You know, from the time that the administrative record is filed, that sets the time limit for the first brief from the plaintiff, which then sets the time for the brief from the government, which sets the time for the reply brief. It's not just a calendar schedule, everything is tied. And so if somebody files a brief early, you might be thinking, well, I've got 28 or 30 days to file a brief, but you don't really know when that 30 days is going to start until the other side files their brief. And so you have to really pay attention to when those briefs come in, because that's going to trigger, I guess it's mostly for the reply brief when the government files its brief, because I've had them file those early before their deadline is required. The U.S. attorneys are very busy. That doesn't happen very often, but it's just a potential landmine that when that brief comes in, that triggers the time period for you to file your reply brief. And if you're not expecting it, and it's like 14 days. So if you're on vacation, you know, you may come back and find out you got 2 days to file the reply brief. So that's all I've got for federal court right now, but I'm glad to take questions later.
Yeah, and that's a very good point about the kind of the new procedures. Previously, we would get like almost like a scheduling order, which would give you those dates. You don't get those anymore. Well, actually, I did just get one from the Western District, but I don't know if that was just redundancy to making sure that people are getting used to it. But yeah, when you get the administrative transcript, then you starts triggering those dates, and you need to make sure you get your briefs in on time, because as we know, federal court does like to fly spec those things. And then also I'll add, with regard to citations and things like that, I know that we probably have some of the people in attendance here that were at our seminar in September, where we had Magistrate Judge Patty and Judge Green speak. And they talked about this as well with regard to citations in the briefs. You need to make sure you're using that page ID code. Some of the magistrates are rejecting briefs. If they don't contain those, they'll let you know. But if you've submitted it at the 11th hour and they reject your brief, you may not have time to remedy that. So you need to make sure that you're putting the correct page ID citations. And those are all contained in the local rules. So double check your district and the local rules for Social Security practice and appeals in those districts to make sure that you're doing everything you can in a proper fashion, so that nobody, kicks your brief out. All right, now we can move on to some work history and function report completion and best practices for that. And I think Greg has got some comments related to that.
I do. Thank you, Josh. Gregory Fry. Been practicing for almost 25 years now. Been doing Social Security the whole time. And we have this from time to time and issues at the hearing level with two specific reports. The adult function report, which comes from DDS typically to our clients, forms 3373, if you are playing along at home, is the function report. And then the work history report, which is, I always forget the form, 3369. And these are forms that if you've practiced long enough, eventually you will have a judge say to you, counselor, your client's testimony is inconsistent with one of these two reports. And if you haven't had that happen yet, then you're lucky. but it will happen at some point. So whether you're doing initial applications, whether you are doing hearing level only, these are reports that you need to pay attention to. If you're doing initial applications, and sometimes recons, because sometimes they will send them out again at the recon level. If you are not reviewing these for your client or with your client, if you are not checking their work on these things, you will find that you end up with inconsistencies that can really damage a claim. The work history report, not as many comments there. It's a fairly simple report, other than people will often put how many hours a day they work, and sometimes they'll put 40 because they're thinking of a week. If they get it right and they put the typical 8 to 10 hours a day, the big thing you need to look at then is walking, standing, and sitting, and how much they were doing on those jobs. Whatever number they put under hours per day should match the total of those three categories. And so you'll often see walking 8, standing 8, sitting 1. Well, that's 17 hours. It's probably not the 8-hour shift they just wrote down that they were doing. So you should work on those for inconsistencies, because there are judges out there that will not question your client typically about their work history, and the VEs are reviewing those forms, and they may come up with a wrong classification for your client's past work if those forms aren't done correctly. The other big section to look at is then how much they are lifting. Make sure they understand when they fill that out how much 10 pounds is, how much 25 pounds is. I did a hearing just yesterday where I asked client, could they lift 10 pounds? And they said, sure. And I said, well, 8 gallons is about the weight of a gallon of milk. Oh, well, I can't lift that. They don't typically know how much they can really lift in terms of pounds. Talk to them in terms of objects and familiarize yourself with how much things weigh. One of those big boxes of paper that has like 8 or 10 reams of 500 sheets of paper. I think it's 10 reams in a box. That weighs about 40 pounds. If you've got someone who is working in an otherwise sedentary occupation, like a receptionist or a secretary or something like that, but they have to lift one of those boxes, make sure that you're lifting, heaviest weight lifted is reflecting, something along those lines. And then lastly, on the work history report, make sure you are spending a little bit of time, especially looking at handling, grabbing, grasping, reaching, and definitely if you have any sort of upper extremity mobility problems, whether it's carpal tunnel syndrome, whether it's tinnitus, whether it's a torn rotator cuff, if they did a job and they didn't accurately reflect what they did there, again, an RFC from a judge may not work well because the VE relied on what they put here. And so you need to watch out for those things. And if you're doing this only at the hearing level, you need to look through those reports when you interview your client to make sure that they are in fact accurate. And if they're not, be prepared to address that, preferably in writing before the hearing, submitted to the E section so that the VE has a chance to see them. And that the judge has a chance to see them. We know the judges sometimes don't even look at the files till the day before, but at least it's in the file and you can say, we attempted to correct this. The function report, the 3373, again, you're looking for those same kind of inconsistencies. The page that has all of the check boxes on it, and if you're not familiar with them, Google it real fast while we're sitting here talking and go to page 8 of that form. You will find that there are a lot of clients who don't understand what some of these terms mean, even though they're very simple in terms of looking at them, sitting being one of the bigger boxes. I often see sitting is not checked, and I'll ask a client, how long can you sit before you've got to get up and move around? A standard hearing level question. And they'll say 2 or 3 hours, and I'm like, what kind of chair are you sitting in? And they'll say a recliner. Are your feet up? Yes, my feet are up. Well, that's no longer sitting. That's more like laying down. And so then that box has to be checked on that form to note that they're having problems sitting. And then in the comments section below that, They should tell you how much they're actually sitting in a regular type chair, 2 feet on the floor. But that will catch you at the hearing level. And yes, I have had judges when I was younger and probably a little less thorough and foolish that have called that out. And you better be ready for an explanation. Thankfully, on that case, that's when we had 2-year waits to get to the hearing level. And I say, Judge, things change in 2 years. And the judge laughed, and we moved on from there. The other form that are part of that form that really causes problems is question number 12, which is the personal care section. If you've done any hearings at all, you know judges will usually ask, you can get yourself dressed, you can take a shower or bath or whatever, and an unprepared client will say, I have clothes on today, so I must have gotten myself dressed. The answer to that question is yes. And of course, we know that the answer to that question is more complex in that, you know, getting dressed isn't necessarily the end result. It's how hard is it to do that? And on those chronically depressed days or on those severe pain days, do you even change your clothes? And usually the answer is no. If the judge goes to section 12 under personal care and they've checked that very convenient no problem box there, you now have a problem. And so again, you've got to go through that with your claimant. Hopefully you're doing this at the initial application level before it's ever sent in to the judge, or excuse me, to DDS, so that they can be corrected before it goes in. Dressing, bathing, brushing their hair, shaving, all of those things for most of our clients will be problematic at some time. I almost never leave that box unchecked when I get a chance to review those questions. And if there is a problem with that, again, be prepared to address that at the hearing level. If the judge doesn't ask specifically about the conflict there, be assured that at some point somebody is considering that conflict. Probably the writer who's looking back through the file for reasons to support turning your client down, and they'll say that their testimony is inconsistent with the record and that, you know, a year, 7 months, whatever, before the hearing, they were saying they didn't have any problems getting dressed. They didn't have any problems using the bathroom. They didn't have any problems taking a shower. So be careful of those things. One of the questions that just popped in was difficulty with how much time spent standing and walking, and how do clients estimate that? I typically don't look for distances in terms of walking. I ask them typically time. Most people I have found have no concept of how far things are. How far can you walk? Well, I can walk a mile. You realize a mile is 17 football fields in length. Oh, I can't walk that far. I could barely walk to the bathroom. Well, then why did you say I can walk a mile? Why did you write that on this form that you filled out that you could walk a mile? Because they don't understand distances. So this is a part where you've got to be an advocate. You've got to help them figure out how long they can walk. And if they, you want to use a distance and they say, oh, I can walk to my mailbox and back, then you have to talk to them about how far away that mailbox is. Does it typically take you 2 minutes to get there, 30 seconds? And I like times better than I like distances on those questions. And if they are having trouble estimating time, then talk about other things that they might do. Watching television, for example, you're sitting in a chair. How long do you sit there before you need to get up and move around? Well, maybe they don't know time. Do you make it through the first commercial? Can you sit through an entire 30-minute episode of your favorite comedy? Or I guess everybody streams now, so there are 24 minutes of sitting there without commercials. So can you sit for the whole 24 minutes without having to get up and move around? If they can, then you've got to ask more questions. If they can't, it's going to be less than 20 minutes. And, help them understand that they can give an answer like 10 or 20 minutes of sitting. Again, when you're filling out these function reports, it asks these things. And so be careful of how you answer them. And we could certainly spend another hour going through each one of these types of questions, but watch out for housework. How much are they doing? Are they taking breaks? When they answer the question about hobbies, are they still doing those hobbies? Do you even want to list what your hobbies are if you haven't done it in 5 years? Is it really still even a hobby? You know, they ask how much do you do it and how well do you do it? Well, if you haven't done it in 5 years, why even bring that question in? You know, advise them that that shouldn't be in there because it's really not a hobby anymore. So I will step aside for now, but we can come back to this if we have anything on questions there.
Yeah, and I'll add something to that as well on the function report side of things, because it often comes up in the hearings where we as representatives are making the allegation that the side effects of our clients' narcotic pain medication or you know, any of their psychotropic medications are affecting them and their ability to function, such that we want a, you know, maybe an unskilled RFC to be posed on the function report. And unfortunately, it's maybe the very last page, gives them an opportunity to write down what side effects they experience from their medications. And oftentimes I will see that they will leave that blank, or they'll say none, which, you know, then undermines your argument later on at the hearing if that's not rectified. So you need to make sure that you're having those discussions with your clients about their medications. You know, maybe they've been taking them so long they don't notice those side effects anymore. But you know, you should tell them, hey, you're on 3 Norcos a day. Are you sure you're not a little bit loopy from time to time? Or you know, you're on this medication. Looks like the side effects of that might be drowsiness. I mean, frankly, I just Google them, and then, you know, on the Google search history or search bar, you'll see on the right side, you'll see the common side effects of that medication. And that's a really good resource to go through with your client to see if they're experiencing any of those, so that they can be ready to amend that, and then also, of course, relay that at the hearing in their testimony. One of the questions we had as well is, what about just skipping the function reports or the work history reports? Is that something that we can do?
No.
Didn't think so.
No, definitely not. If you don't do it, it'll be considered a failure to cooperate on behalf of your client, and it will give them an easy reason to turn them down on a failure to cooperate. It is kind of a pain, and it is a time user to go through this. I typically have the client fill it out, send it back to me, or drop it off or whatever, and then we go over it. And I make changes with their permission on the form, so they don't have to come in and do it. And I've never had anyone at DDS or a judge say, hey, this is different handwriting on here, you know, and question it. So yes, you have to do it, but that doesn't mean you can't spend the time with your client to correct the problems. And I typically look at it, know what the problems are, call them, explain to them why these are problems. And they typically say, well, let's, you know, change it, you know, and then they tell me what they want to put in there after they understand what the problems are.
Yeah. Yeah.
Yeah, and I've put it right on there when I assist somebody. Sometimes we've all had clients that they have issues where they can't write, you know, the handwriting. I've sat down and I write their answers out for them, and I'll put, you know, at the end of the form, it isn't a signature. It says, you know, person completed the form, and I'll put, you know, John Doe with assistance of counsel, and I'll put it right on there in the form, and I think that's appropriate, and I've never had any issues.
Yeah,
I did that for a sight impaired person one time too. They just simply couldn't see the form well enough to fill it out. So same thing. I don't think they care who completes it ultimately, as long as the answers come from your client, and that to me does not say anything about you can't advise them why an answer is not good. I don't think you could give them the answer. I think that would be inappropriate, but you can tell them why their answer doesn't seem good and ask them if they want to change it, which they will.
Yeah. And Josh, to kind of go off of what you mentioned about the side effects, I've had situations where, I mean, our clients sometimes aren't the most sophisticated individuals. They don't know which one of their medications is causing the side effect. And I put that on there. I don't know which one. This is what I experience. And,
Yep.
you know, my doctor might know, you know, which one is causing the side effect. And I think that makes sense to me.
Yeah, I agree with that. We did have a comment about that as well. You know, when you're taking multiple medications, sometimes the list is long. It is hard to differentiate which one of those medications is causing it because they all cause drowsiness. At least every single one I've ever seen, that is a common side effect. So, yeah, and that's a good point. You don't necessarily have to attribute it to a single medication unless they know. Maybe they just started taking it and they just recently realized that that's a side effect that they just started to experience. Or, you know, maybe they've discontinued it at one point and that side effect got better. But then of course, maybe they have to still take it despite the side effect, because not taking it is worse than the side effect that they experience, of course.
You know, one thing about preparing the forms, what I've done sometimes these people have terrible handwriting, right? It's almost impossible to read it. I've actually had my secretary retype the whole form, so it's legible, which I think is helpful for the DDS, but it also gives you a chance to edit the thing and make it sound you know, reasonable and understandable. And like Nick said, it doesn't have to be signed; it just has to indicate, you know, who prepared it, and so. I don't do that a lot, but sometimes I think they really are hard to read, and you can fix all the spelling errors and the grammar errors and make it sound much more understandable.
Yeah,
Tom, I actually don't fix the spelling errors and grammar errors, especially if I have a low IQ client, or one with cognitive impairments, or one that is claiming, you know, those types of impairments. Low reading skills and things like that, because I want DDS to see that, and I want there to be a record, you know, that they have troubles with coherent thoughts and they have troubles with spelling and things like that. There does come a point, though, where you're right. If you can't even read it, what is the value of the report? So.
And sometimes I've done this. I've had it typed up so it's more readable, but then I attach the two together and send them in so that they can see it's just a typed up copy of what the claimant said, and then you don't fix all the mistakes.
Yeah, that's a good idea.
That is a good idea, and I would add that is good advice. Maybe obviously if you're helping assist, or if you know that somebody's helping them assist or assisting them in completing those forms, to make that known. But also maybe when they come to you later and they've already done it, you ask them, you know, did you have any assistance completing this form? Did you write these answers yourself, or did somebody else did, and maybe it's just not indicated? Because, you know, I think we've all had this come up before, you know, with regard to a claimant that says they have trouble reading and writing or comprehending and understanding. You know, the judge can look at that and say, well, you filled out a 20-page function report. It looks like you answered all the questions just fine and you understood those questions. You get that with the driving license as well. You know, they might ask, well, if you have difficulty reading and writing, how did you pass the driver's test or the written test? And of course, you question them and they say, well, I was able to get it orally. They gave that to me via an oral test rather than a written test, or maybe they just haven't been tested with their driver's license in quite some time. But that's important too, because you know, the judge is only seeing what's on the paper. And, you know, if that was completed by somebody else and it wasn't noted, then that, of course, is going to undermine any later claim you're trying to make that they have difficulty with comprehension and reading and writing and things like that.
And Josh, we had a comment about third parties helping out, which reminded me of the third party form, the third party function report, which they send out. And they want the spouse or the adult child or whoever to fill that out. And you will see them come back in the exact same handwriting. And so, you know, if you see that, you should definitely question, you know, the client to make sure that on that part where it says who filled it out, that they're listing that the third party person filled them out. And I don't know about you guys. I don't know what you do with third party forms. I kind of struggle with those because you know, we want them to be reflective of our client's situation. Sometimes it's hard to go to that third party and say, hey, you kind of made a mess of my client, your spouse's, your child's, whatever report here. Can we talk about it? And I don't know that we're running on any ethical boundaries there, but you know, if it's a parent representing a minor child, well, they wouldn't be doing this form, but a parent representing a 19-year-old child who's got impairments, you know, I think it's our duty to check those forms as well for the same kind of inconsistencies and problems we're talking about. So that was a good point that someone brought up on that.
Yeah.
Yeah, I kind of, with the third party function reports or the, you know, the third party statements or letters, I often, to me, I kind of address it on a case by case basis. You know, if it's a seizure case or something where you're kind of, there's not a lot of objective evidence maybe, and you're looking for other sources to kind of, you know, establish the proofs for your case. I'll frequently do that, and I certainly I've talked with parents or spouses or whoever is going to go over those third party reports, and you're kind of pointing out the same stuff you are on the function report. You're addressing these things. Okay, it's sitting not in a recliner, sitting in this chair across from my desk. How long is they going to sit in that thing? Or and a lot of times you can get more, from my experience, you can get even more honest responses from a spouse. You know, I've had how many clients that, you know, they're a skilled trades guy that have worked hard their whole life, and they don't want to admit to emotional issues or, you know, things that may, you know, kind of make them feel like they're weak or something. They don't want to admit to some of those things, and their spouse is the first to, you know, they're elbowing them. Well, tell them about, you know, how you were crying the other night, and they don't want to tell you. So.
Yeah, that's a good point. And I'll add that sometimes the inconsistencies between the third party and the first party function reports, there can be a very good explanation for that. And what I mean by that is when you're dealing with somebody who has got some pretty significant mental illness. I have had some cases where you have a person who absolutely lacks insight into their condition and their mental illness. You know, they think they're fine, or maybe that day they think they're fine. And some of this might be more kind of hearing practice as well. You know, I've had one client who we had a hearing, and you know, he testifies, oh yeah, I always take my medications, and you know, yeah, I'm fine, you know, things like that. And it's like, well, you wouldn't be here if you were fine. But, you know, we have his spouse and significant other out in the lobby, and we bring her in, you know, to testify. And then she's able to provide that perspective and say, no, he doesn't take his medications. He lies about it. You know, he'll rattle the bottle and make me think that he's taking them, but I can tell that he's not taking them. And then, you know, that might be a time where you might want to get some recorded statements from some doctors too, to talk about that, because those present some very difficult issues where you have the claimant who, quite frankly, doesn't believe or lacks an insight into their condition. And you need to have some explanation from others and third parties and doctors and providers, if you can get them, to talk about that and show that, no, that what this person is saying is just not, it's not accurate. And hopefully the treatment records will reflect that, of course. But that happens a lot. I've had a lot of people that, you know, especially paranoid schizophrenics and others, that are suspicious of taking their medications and they don't want to take them. They don't trust doctors, they don't trust lawyers, they don't trust anybody. And that can present a really big issue. So,
you know, we had a comment about whether these forms are worth the paper they're written on. And I think the answer to that is yes. It's kind of a situation where if these papers are wrong in terms of inaccuracies, you can be assured they're going to be used against your claimant by somebody somewhere along the line in this process. I think what this discussion about today, and the reason that I thought it was worth a topic here, is that, you know, we have the opportunity to make these forms good and to help our clients to get out the right answers for them. And so if the forms are good, they say what we want them to say or what the client needs them to say, and they're never referenced, that doesn't mean they're not looked at. Again, that judge who is intent on finding bad things about every client, and we all know who those judges are, they're going to look at these forms. And if what the client is saying in testimony is consistent, then it's at least going to get a check mark that they're being consistent. And whether they're going to get paid or not, totally different question. But at least they get that check mark that this person said when they filled out this form they had trouble getting dressed, and here they are in the hearing saying they have trouble getting dressed, or that they had side effects to their medications that he listed them then, and they're on the same medications a year and a half later, and they're still having side effects. The consistencies at least help us to show what's going on over a period of time with our clients, and to me that's the most important thing. It doesn't matter what happened a day ago or a week ago. It mattered what happened at the alleged onset date and every day since then. And so if you have a form that's filled out relatively close to the onset date, it's like having that medical record that supports the onset date. If this form is wrong, that's where the damage comes in. So is it a big pain in the tail to get it done? Absolutely. But it's worth every second you spend on it down the road to keep from having these problems if you end up at the hearing level.
Yeah. One thing we didn't touch on, and I thought one thing I always like to do also is on those function reports, that's kind of the first document that they're kind of looking at, whether they believe your client or not, your credibility. Does this person seem like they're being straight shooter or not? And I think it's our job as advocates, as attorneys and representatives, that you want to make your, we want to be consistent, and you also want your client to look like a credible witness. And so that means making concessions and not trying to make it seem like every single question on that form applies to your client, because they don't. If, I explain to my clients all the time, they get confused by some of the, if they're here for a back issue and it's asking about getting along with others or supervise, I'm like, not all these are going to apply to you. And that's fine. And I think you need to make those concessions on some of those questions that don't apply to your client's case, because it looks more credible to somebody reviewing the file. Okay, they're not trying to say that everything under the sun is disabling them from work. I mean, we've all had it where somebody says their depression is the reason, they clearly have like a MRI supporting a severe back issue. And then they ask them, well, how come you can't work? And they're like, oh, I'm depressed. And they don't have a single record with even referencing depression. It's one of those things I think it's just, you gotta be on the lookout for.
Yeah, and the credibility and the testimony at the hearing too. Hopefully you all are preparing your clients before the hearing, and not just 30 minutes before the hearing, but a day or two before, and hopefully before that as well. I always tell people that it's not just the number that you give to the judge when you're answering their questions about how long they can sit, how long you can stand, how much you can lift and carry. Providing the whys is what I say. Why? Why is that? How do you know that number is that number? I give the example where you might have somebody that is asked how long can they stand, or how much can they lift. And, they may say 10 pounds. You say, well, how do you know that's 10 pounds? And well, because when I go to the grocery store and I lift a gallon of milk out of the cooler, I have to use it with two hands, and I start to get numbness and tingling in my leg. I start shooting down my right leg into my toe. And I know if I lift more than that, or I lift longer than that, I'm going to be in trouble and I'm going to be in a lot of pain. That's the same answer. Still a 10-pound answer. But you can tell, and I tell people, you can see how that second answer shows that some thought and some foundation has gone into answering that question, rather than just spitting out a number because your lawyer said that you need to be sedentary and you can't lift more than 10 pounds. So I know we don't deal with rules of evidence, formal rules of evidence anyway, in Social Security hearings. But those of you that might be familiar with litigation, establishing a foundation for answering the question is kind of like how I view it. How do you know that you can't stand for more than 10 minutes? While I'm standing at the sink doing my dishes, and my legs will start giving out. My back's just hurting so bad, I got to go lie down. So that provides some extra context to the answer too. So that's important. All right, moving on, we do have some one of the more difficult cases to prove, migraine headaches. And Nick, you have the honor of teaching us how to win these.
I'll do my best. No, I've actually, early on in my career, I guess I never introduced myself. My name is Nick Romer. I practice out of Grand Rapids. I cut my teeth doing nothing but Social Security Disability right out of law school back in 2013, and I've continued practicing in the area ever since, although now I have a couple other practice areas. But, early on in my career, I thought migraine case headache, I hated them. I'm like, I usually don't have that MRI I can point to and most of the time to demonstrate the diagnosis or the cause of these symptoms. But I've really learned and found that they can be very strong cases for people that are, they're doing the right course of treatment, they're doing the right things. They can and often make very sympathetic witnesses, from my experience, because they've been in agony for so long and they're just kind of defeated. And it's transparent when you talk to these people. And so, Social Security came out with, there's a ruling on point, SSR 19-4P, which we're all probably, hopefully familiar with. And they kind of, I won't get into the weeds. I'm going to focus more on practical tips here. It distinguishes between primary or secondary headaches and what's a medical determinable impairment and what's not. And for all intents and purposes, I think you kind of get to the same point. If you have an impairment that's causing these symptoms, if obviously a secondary headaches are more things like, you have a brain tumor, or you have headaches, following a TBI, or due to, high blood pressure or something else that's causing the headache. Social Security doesn't really, they look at the underlying impairment as the severe impairment or the medically determinable impairment. But either way, and then when we're dealing with primary headaches, migraines, cluster headaches, those things, it's kind of a diagnosis of exclusion, and they kind of rule out other causes like the TBIs, the brain tumors, stuff like that. And hopefully, if you have a case where you have a client that's treating for migraines, they're treating with a neurologist. That's one of the first things I ask when somebody comes to me for a consultation and is looking for disability, and I ask them if, are you seeing a neurologist? And most of the time the answer is yes. And and then my next question is, well, are you keeping logs of your migraines? Because I have found that is pivotal in these cases. And there's so many, there's a lot of apps out there now. Because I know, 10 years ago, I'd talk to clients and they'd say, well, I started one and I put the pad down. I don't know where I found it and I lost it. Well, now they have these apps and they're so detailed, a lot of them. You log in, it gives you log the duration, you log the severity, symptoms, did I have phonophobia, photophobia, and so that hits on all the big things that Social Security cares about in these migraine cases: duration of the migraine, severity of the migraine, symptoms, and so those are kind of your, other than a medical source statement, those are your best evidence, in my opinion, in proving these migraine cases. And a lot of them, those apps, they can just email them to you. They can print a report and they email them to you. And I just save them to a PDF and I upload them right into the ERE. And it also has the benefit of they have those logs for their provider also. Because a lot of times the provider tells them, keep logs if you can. And sometimes clients are already doing it and sometimes they're not. I'm like, well, it's really, it'll be helpful not only for your doctor, because then when you're going into your doctor, you can show them, well, this is what it's been like over the last couple months. And it develops that consistency. and for purposes of our case, we care about consistency. So when we're submitting documents that are, that are being contemporaneously recorded of their migraines, the severity, the duration, the symptoms that we're submitting into the file. They have those contemporaneously recorded records that they now have available to show to their neurologist, to their treater. And so you would think that the records, their medical records, were going to be consistent in that regard. And then when they present to their hearing, a judge is going to ask them, well, how often are you having a migraine? How often, how often do you have a migraine? Well, how typically long do they last? Well, all of us know you have clients that say, well, short ones, couple hours. A bad one I could have for days. So what they can do is they can say, well, this is kind of the general range, generally speaking. But Judge, I think I kept logs, and I think my attorney submitted them for me. So I would direct you to those. That's the best evidence of the duration, the severity. And I haven't, most of the judges, from my experience, appreciate that. And all these things, I think, go hand in hand right in with proving your case, both at a listing level and if you fall to the RFC. And so the listing, obviously, SSR 19-4P talks about, medically equals a listing. You're looking at 11.02. Which is for epilepsy. Kind of the same, that particular listing, that one discusses seizures occurring at least once a week for at least 3 consecutive months, despite adherence to prescribed treatment. So I kind of make the analogy, well, okay, instead of a seizure, we're talking about these migraines, and so the big things they're looking at is frequency of headaches, a description, in the types of symptoms they're experiencing, phonophobia, phobia, aura, those kind of things, side effects from treatment. And what I also do is like we do in all cases, I like to tailor my medical source statements or my medical opinions, my questions to doctors. I like to tailor them specifically to each specific case, as opposed to, I know some people just send a standard form that doesn't apply in all cases. And I'm not, to my neurologists, I'm not asking them how long can they sit, how long can they stand. I'm asking them about, frequency, duration, symptoms, those things. And I've had good success in that regard. And sometimes, the judge will find the listing, and other times, they address it at the RFC. But then we're looking at things like, how are these symptoms accounted for? Obviously, if somebody needs to go into a dark room, periodically throughout a week for extended periods of time, I mean, I think we all could agree that would be work preclusive. Now, I have a good audience for that argument, but also you're looking at, photophobia, phonophobia, sensitivity to sound. I've had, those can, an RFC limiting somebody to a quiet work environment or something like that. Those eliminating jobs when you're trying to grid someone out. They can't look at a screen because screen time aggravates their migraines. These are all things that I've had come up in these migraine cases or headache cases, and so there's a lot of ways it can deteriorate the occupational base at step 5 with migraines. But those are kind of the big take homes, I guess, to summarize. Is I think you need to tailor your questions to hopefully you can get a neurologist to provide a medical statement. And I've actually had pretty good success with neurologists that are treating patients that are suffering from migraines, and they're usually long-time patients from my experience, and getting the logs. I think those are big. And then also, if there's a partner, a spouse, child or someone else in the home that witnesses, yeah, I got to keep I come home from work and the lights are all off, and those things I think are very compelling stories. And I usually will have somebody do a letter just kind of pointing some of those things out, and that all just kind of layers the evidence where, yeah, maybe you don't have that MRI that you can point to, but when you start layering all this evidence and all points to one thing, and it lines up consistently with what Social Security is looking for under 19-4P, I think I look at these as strong cases now. When I got somebody that has migraines or headaches that's treating with a neurologist, I think they're good cases.
If I could throw in there, the fact that the epilepsy listing is what we look at reminds us that there are other cases where logs work as well. And we had a comment about gastro issues, but seizures also. I am always surprised with migraines and seizures, the number of people that their doctors either haven't told them they should be keeping a log of those things, or they just disregarded it. But Nick, you are 100% right. I submitted 247 pages of logs one time because each entry was one page off of the person's app that they used. And the judge was like, I'm not looking through 247 pages. Are these all headaches? I'm like, yes, Judge, they are. And, the judge found, and it was a good judge, but he found it very persuasive that he had taken the time to do that. I would, however, also mention, along with what you were saying there, is it's good to have a backup on that. A person, whether it's a family member, spouse, child, whatever, they can make sure they're actually completing those logs. And that's certainly a problem. I frequently used to get migraines, very infrequently now. But when that's going on, the last thing you're thinking about is making a record of it. And when you finally recovered from it, you're not necessarily thinking of that. So if you've got a spouse, a partner, an adult child or whatever that can help you to keep that log, it's a really good thing. I also wanted to add that, triggers are an important thing in both seizure cases and especially migraine cases. And you hit on it a little bit with screen time, but there are a lot of triggers for people with migraines, and they don't always know them. But strobe lights, bright flashing lights, I get them if I'm in a sunny day and the car in front of me, the sun hits it just right, I can potentially get one. You can get them from too much caffeine, even though caffeine is a treatment in most migraine medications. It can cause that. Dehydration can cause it. Overheating can cause it. And you start to find work-related things that you can eliminate from an RFC if they have these triggers and they're testifying to these triggers. You suddenly need to be in a controlled environment, or no, exposure to heat, no exposure to, flashing lights, and things like that. And so those are good things to learn what those triggers are. And for better or worse, the epileptic triggers and the migraine triggers are often very similar. And so in learning more about migraines, you learn more about epilepsy as well in terms of presenting them in a case. And I don't want to forget our comment about the gastro issues, because those are certainly a great thing to keep logs on too. How many times a day you're going to the bathroom, how long you're in the bathroom when you're there, very much like what's the recovery period from a migraine, how long are you in the bathroom after you've had, the 7th bout of diarrhea that day. All of those things, connect together in terms of advice for questioning your clients and presenting your claims. And I hadn't even thought about how those were all sort of connected together till you presented that, Nick. So thanks for sort of connecting those to let us think about that.
Yeah. Good. And we got a little bit more time here. We'll probably wrap up a little early, but I guess now that everybody's kind of going back to in-person hearings, or at least they're being offered again, along with the VTC and phone hearings, I think it'd be kind of interesting to get the perspective from you guys as to what you're doing now, moving into the kind of the post-COVID world here, where we do have some in-person hearings that are being scheduled. I know I've got a lot more that are being scheduled. I don't mind them. Obviously, having to travel again has its benefits and drawbacks, but I will say that I think for the couple of in-person hearings that I have had, they've gone relatively well. You've got to remind your clients, of course, that they're still observing COVID protocols at the Social Security offices, which include masking requirements. They usually do have a mask there if your client forgets one, but you know, some people are still of the opinion that they don't want to wear a mask and they can't wear a mask, or they refuse to wear a mask. So prepare them for that, so there's not an issue at the hearing office the day of because their client refuses to wear a mask. Also, some of them have had the plexiglass. I've been in a couple of others where they've taken the plexiglass down. I've been in some hearing offices. They're all kind of doing it differently, and I understand that they have their limitations with respect to the hearing rooms themselves and what they can do inside those rooms. I think in Grand Rapids, I think they're still having you sit next to your claimant, so you're not separated. Lansing, OHO, however, your claimant's on one side of the room and you're on the other. You kind of feel like a court reporter because you're in the corner. But overall, I think they've been okay. They've been well. I still leaving it up to my client, of course, telling them my experiences. I don't necessarily keep track of my statistics, wins and losses, or, phone hearings versus video hearings versus in-person hearings, and whether or not I'm winning more in one modality than another. That's often what they want to hear from me, but, I tell them every case is different, and it really depends on you as the claimant, as how you're best able to communicate. If you can communicate well over the phone, in relaying your symptoms and your issues, then that might be an acceptable way of testifying. If, on the other hand, you need to have that eye-to-eye and face-to-face in-person ability to comprehend and see and read the room, then you may want to do an in-person hearing. But what's all your guys' experience now that we're kind of transitioning now?
Well, I have not had an in-person hearing yet. But my take on it is I'm fine with the phone hearings. However, if I have a client that I think presents very impaired visually, I think that's something I want to get in front of a judge, as opposed to, if not so much, if I don't think visually it's going to add any value to the case. I'm fine with the phone hearings. Are more convenient for the client, for the judge, for us. But I mean, I certainly I'd be happy to do an in-person hearing if I thought that the person presents well or presents very impaired and it's going to add value to the claim.
I've done 2 of them, and I swore after the first one I wouldn't do another one because it was in Lansing. And I kind of felt like I had walked into the correctional facility because, you get the SWAT treatment when you come in the door. And thankfully it was Judge Ambrose, who is nice as can be. But we were sitting initially on separate sides of the room. The microphone wasn't long enough, so I kind of moved to the middle of the room. The hearing monitor had her mask on like a chin guard, so she really wasn't observing it. And my client spoke very loudly. She was a very loud person. And Judge Ambrose, told me that, that's been one of the problems, is actually hearing the clients pretty well through a mask. So I just said that, the whole experience for me was not a positive one. I did do another one recently, and it was an adult child, and client's mom, who was actually legal guardian, insisted that it had to be in person. And after the hearing was over, the judge and I talked for a few minutes. One of the things that is nice about an in-person hearing, she was like, it was fine you guys were here, but you really didn't need to be here. These hearings we can do just fine over the phone or Microsoft Teams. But client's mom wanted them to see his face because he had some facial deformities from birth that were indicative of the type of condition he had. Well, got a mask on, you can't see their face. And everything that happened in the hearing in terms of the personality things we were dealing with and stuff would have been easily seen on video. But I know of an attorney who wants to do all of the hearings in person and has had a good success rate with that. So I think it's kind of your own preferences on it. I don't think phone hearings and Teams hearings are going anywhere anytime soon. I think Social Security is very happy with the idea that they can ship your case off to wherever, kind of like they used to do when they were, for anybody that's been around long enough, the days when we had cases in Dallas, Texas, and Tulsa, Oklahoma, and Minneapolis, Minnesota, Chicago. The national hearing centers are very much alive. They very much are still processing cases and turning them down. And so I don't think Social Security has any incentive to push back into in-person hearings. So I think it's going to be one of those things where you've got to go do some and see whether you like them or not and whether they're beneficial to you. I think most of the judges don't feel that it's impaired their abilities to issue good or bad decisions. And I'm sure I've lost some cases because they couldn't see my client, and I'm sure I've won some cases because they couldn't see my client. So it's definitely going to be a trade-off there, but that's my experiences with it.
The 300-pound buff.
I guess I'm the
correction
outlier.
guard that can't lift over 10 pounds.
Exactly. Go ahead, Tom.
I may be the outlier here. I've had 14 hearings so far this year, and 10 of them have been live. Partly that's because my office is a mile from the hearing office in Grand Rapids, so it's no big deal for me to go. I would say, though, I had 2 hearings in Mount Pleasant live, 2 consecutive mornings, 9 o'clock. When I arrived, they told me the hearing had been canceled. And that was really irritating. 2 days in a row.
Reason?
Well, the judge was sick the second time. So first time, the judge decided the day before that he needed a medical expert. It's a really old remand that I took over for somebody else. It was a single decision maker, so there's no medical opinion in the file. I drove up there confident that I was going to win that case. And I get there and they say, well, we're adjourning this to get a medical expert. And so that's one problem with live hearings, right? And I've now told the scheduling people, do not schedule me before noon in Mount Pleasant because I don't want to do that again. 2 days in a row is too much. And partly some of those cases were live because they were remands, and we said, let's do something different this time. Partly there were some people who just want to have their day in court and they want to see the judge. I find though that people with anxiety disorders really like the phone hearings, and so not all of my hearings have been live. There have been, like I said, 4 of them now that were either video or telephone. Yeah, I guess when I talk with my people, a lot of them, they just want to have that chance to talk to the person that makes their decision. There is an issue with sound, not only because of the mask, but the plexiglass, right? You're talking through a mask, through plexiglass, although the judges have seemed to be able to hear okay. That's one of the things you have to coach your clients on beforehand if you're going to do a live hearing, is that you got to speak up so the judge can hear you. But if the judge can't hear you, the judge will say, hey, could you repeat that? If the judge is repeating everything back, did you say this? Did you say this? Well, then you know that there's a problem with the sound. But it is odd in Grand Rapids. They have you sitting right next to your client, no plexiglass, whatever. You're just right next to them, and everybody else is separated. It's interesting to talk to the security guards because there's not a lot of live hearings. And so they don't get a lot of people. What's been happening is people who don't respond, right, unrepped people who don't respond to the paperwork about what kind of hearing you want, eventually they schedule those for live hearings. Well, they'll schedule 20 in a day, and most of them won't show up. Maybe none of them will show up. And that's how they're clearing a bunch of those cases. And for a while, if you asked for a live hearing, it could slow down the processing because they had so many of these sort of deadwood cases out there from way back when they couldn't force people to come in, that they had to clear all those. And so if you asked for live, well, then you had to kind of wait until they had a space for them. I think, at least in Grand Rapids, they told me they've worked through most of those. And so there is no extra delay in asking for a live hearing. And so yeah, we've had mixed results. We've won some, we've lost some live. I don't think it made a difference whether it was live or not. There was one live hearing I had where my client wanted to do, she was a bank teller, and they said she could still do her past job. And she says, I can't even make a fist anymore, Your Honor. And she was able to demonstrate, how limited her hand use was. He could have done that on video too, but it seemed the judge said, I'm going to find in your favor in that case. And it was a judge who didn't have a real high pay rate. So that was kind of nice. The other thing that was nice, the first couple of times you go back, it's really kind of fun to be back in the court and to see these people again, right? For a couple of years, you're just doing this from your office. You get to see people. The judges were cheerful and they're good to see you. Just talk a little bit and that kind of wears off after a while, but it's good to be back. It's good to be back in the saddle again, and put on a coat and a tie and go do a hearing, get dressed up and so yeah, it's I'm doing quite a few of them. Most of mine are now live, and I don't know that that's going to continue, but that's what people have been choosing, a lot of live hearings.
Well, that's good to know, Tom. I know that, yeah, that was my experience and understanding from the Grand Rapids hearing office, that you were waiting longer if you wanted a live, because what was explained to me is a lot of these unrepped people that were getting cut off on like CDRs and stuff, they became savvy to the fact, well, if I request a hearing and I want a live one, it's going to take them forever to get me scheduled, and I can continue getting benefits this whole time. And so that was kind of something, they had a huge backlog, I think, of those type of cases that they were trying to push through in the live hearings first.
Yep. There are some comments here in the comment section that some practitioners, and I would be one of them too, to have their clients come into the office, even if it is a video or a phone hearing, especially with the video hearings too. Microsoft Teams can be a bit of a bear if you don't have experience with it, and a lot of our clients don't. And so getting that set up, making sure it's running correctly, the mute, unmute, camera functions, all of those things can be difficult for them and just add stress to an otherwise stressful experience for them that doesn't need to be there. So it is a good idea to have them present. Also, you can help them with their presentation a little bit. I remember, you try to tell people, what they should be appearing like on video, not necessarily, suit, coat, and tie, but not, lounging across your recliner with a bag of Cheetos in your lap either. That's not not necessarily, to me, it's bad, and I think to some judges may take offense to that, of that very informal nature or the disposition that your client is showing, and they could be somewhat offended by that. So you want to make sure that that's not an issue. On the phone hearings too, you want to, I tell people it is like a conversation over the phone, just like a conference call. But it is being recorded and a transcript is being made. So you need to make sure that we don't talk over each other, for instance, or that when the judge is asking a question, you make sure he's finished before you begin to answer, because, I think the phone adds a little bit of that informality where people, like to talk over each other, and then you're going to have a messy transcript and things like that. So I think those are good reminders if you are going to proceed with a phone or a video hearing. Yeah, one other benefit of the phone hearings, according to Jacob, is that all of his suits shrunk drastically for some unknown reason. That's right.
It's the dry cleaner. They did it.
Yeah, that's right. Well, my dry cleaner in town went out of business. There's so many people that are no longer going in the office.
I do want to say one thing on your comment there about Microsoft Teams, though. I have found that if you talk to the client the day before the hearing, make sure that they have the link. Have them click on the link, download the software if they want to, and then log in. And it will take you to the screen that says someone has been made aware that you're, ready for your meeting, or someone will let you into the meeting soon. If they get to that point the day before the hearing, then generally they're not going to have any problems day of hearing. And I kind of have about 50-50 between them coming to the office and sitting there with me versus them doing it on their own. And at least over the last 6-8 months, I think people have really gotten so used to the technologies and stuff now that they are handling it pretty well at home. And as long as they log in the day before, I haven't had any problems yet. The ones that wait till the day of, they haven't downloaded the software. They haven't, figured out how to get into it. And the mute button and the video button and all that, they are still going to probably have some issues. But other than that, do it the day before, and I don't think you'll have any problems. But I also, on videos, I tell them, you are on a hearing, but I don't want you dressed up for the hearing, and I don't want you to look like you just rolled out of bed, but I don't want you looking like you're going for a job interview either. And that's the same thing I would tell them if they were coming to a live hearing. I've had some people show up in the only clothes they have because they're homeless, and they would be kicked out of a normal judicial courtroom for how they were dressed. I'm fine with them coming to the hearing like that because it shows to the judge, how destitute they are and how bad their situation is. I have a client that I will never forget. It took 3 hearings before I finally convinced her to stop coming with her hair all fixed, stop coming in with her makeup all done, stop looking like she's heading out for a formal dinner date that night, because I think the judges very much held it against her that that's how they dressed. And should that happen? No. And is it in the rules and regs that they should not look at your client and make a decision based on how they look at whether they're disabled? Absolutely. Do they do it anyway? Yes. So have them dress like you want them to dress, showing what their problems are. If they have depression and they don't do their hair and they don't do their makeup, and they've written that in that fund function report we were talking about earlier, and they're going to testify to that, but they show up on video or in person looking like they're heading out for a night on the town, there's a disconnect there. And so be careful, on those things as well.
Yep. Also be careful in the hearing office in Grand Rapids with opening the door after the hearing. If you've got a claimant that says he can't pull more than 10 pounds, you might want to get the door for him.
I joked with Judge O that was planted there on purpose. That was a scheme.
Or the client that puts their cane on their hand, uses the cane hand to open the door, and then carries the cane in their arm over to sit down. Had that one happen once too. Judge noted it for the record.
Oh yeah.
Yeah.
All right, guys. Well, I think that just
one thing about preparing the hearings. If I do a video hearing, I always prepare with my clients about a month beforehand. I have a conference with them, and then I do that by video. I schedule a Teams meeting so they have time to load the stuff, and we practice all this stuff, and we do the prep on video. If it's going to be a video hearing, we do prep on video. If it's a phone hearing, I do the prep on phone. If it's a live hearing, I do the prep live. And then you get the chance to work out some of those problems with the computer, because a lot of people are using their phone, right? And it doesn't get the best picture, or you don't, maybe they're living somewhere where they don't get very good signal. Well, you need to figure that out. It's nice to know that well in advance.
Yeah. That's very.
Josh, I do have one more thing, and I want to circle back to scheduling real fast.
Yeah.
The judge that spoke today, we had an off-camera discussion before we went on about it. It's a hot button issue right now with Social Security, and if you haven't had scheduling problems, you haven't looked at your calendar, because I think everybody that's dealing with more than one OHO is going to have scheduling problems right now. It really is the Old West right now. They have not started calling us like we were told we were going to be. They're trying to use our spreadsheets to figure out when we're available. They aren't apparently entering things into the system timely, so we're getting multiple hearings scheduled on the same day. And if you have any kind of volume practice, you are going to see these as issues. And I just bring this up one last time just to remind you to look at your schedules and make sure you're not having problems. Don't let them issue notices that you ask for an adjournment of the hearing. I mentioned that to the judge that we had today. It's a problem with your client relations because they think you're doing something bad with their case. Why did you ask for an adjournment? Lay the blame on Social Security. Now, he said to do that, but it's hard to do that when you get a form in the mail that says, I've granted your request for an adjournment. Don't let them do that stuff to you. Insist that they fix their mistakes. Insist that they fix them on the phone with you right then and there. The schedulers have the power to move things around, even if they've been noticed. And make sure that you learn who your schedulers are. I hope the judge will get us that list that he said he's trying to get for us, so that we can deal with those issues. But make sure you're checking your schedule if you have a volume practice, or even not a volume practice, because there will be problems.
Yeah, that actually brings up another question about the scheduling. I've been getting inundated with a lot of the advance notice of hearing waivers. You know, the form that the claimants are getting, I'm getting. I don't know why suddenly it seems like they fire up the printing presses at SSA every once in a while, and you just get like 100 of them in one day. But how are you guys handling though? I've kind of been saying, you know what, I don't want to submit that because I don't want them jamming in a hearing somewhere, you know, next month or whatever. And then now I've got to prepare for that among my 10 other hearings I have that week or something. What are you guys doing?
I haven't seen a lot of them yet, but I don't agree to them unless the OHO has called me and said, hey, we can slide this in here. It's a remand case. We need to get it done, or it's an aged case. We need to get it done. And I know ahead of time that I'm agreeing to a 30-day window or a 45-day window. Then I will, of course, agree to it and fill it out. But other than that, I'm like you, Josh. I'm not going to give them, you know, extra time just to make my case more difficult, especially if I got a case where I know medical records are going to take a while to get in because they're from a provider that we just know isn't going to get things done quickly.
Yeah, that's how it used to be. You know, if they were going to schedule it before that window, they couldn't get the notice out in time, you would get a phone call. You know, you get a phone call and say, hey, we've got this date and time available. Would that be something you'd be interested in? And then you say yes, then they send out the form. But to me now, they're just sending out the form even when you haven't had any contact with anybody. And for me, I'm like, I can't agree to that.
Have you agreed to one and had them just schedule one 30 days out without calling you first? Because I don't have a problem waiving it, because I think you have the option, like you're waiving it, but you can also back out of it if that hearing doesn't work or it's too soon or whatever. I think you can opt out of their proposed hearing, you know, if there's one in 30 days or something. But I haven't signed one and then had them just unilaterally without calling schedule one like 30 days out. I haven't had that happen yet.
Sure. Yeah, it looks like some of our comments are saying that they haven't seen that happen either as well. But that's why I haven't been doing it, so I don't know. And you know, I don't know, are they jamming those in? Looks like most people are saying that they're not, but I'm just worried about the possibility of that happening, I guess.
Grand Rapids sends them out as with the COVID and the VTC forms. I mean, you get one on every case, and I don't normally sign them again because I don't know when, and I need time to prepare. I can tell you on those 2 cases in Mount Pleasant that got canceled, I did sign forms because they said, oh, we'll get this rescheduled as soon as we can. It's 4 weeks. It hasn't been scheduled yet. In fact, I've got to call up there and find out, you know, why is this not rescheduled yet? You know, because they told me they would reschedule them promptly. So I don't know, you know, the problem when of course, now you got to explain another form to your client. Well, we could waive the 75 days. Oh, let's do that. You know, let's get the hearing right away. Well, hold on. You know, you don't want it too quick because we got to collect these records and we got to prepare. And so it's just another thing that you got to talk to people about. I wish they would do it.
Yeah, I mean, yeah, if your client's treating at all Spectrum facilities and you get everything with a Hitler or something, then it's like, all right, yeah, let's roll. But it's not always like that.
Yep. All right. Well, I think we'll wrap it up there. So I want to thank everybody for attending once again. Hopefully you've gotten a tidbit or two that can help you in your practice. Always, you know, these things can sometimes be overwhelming and whatnot with all the information that's coming your way, but I take it that if I can take one or two things from a seminar that I didn't know yesterday, that's probably a success as far as attending it. So hopefully you've picked up those one or two tidbits. Another reminder, once again, I noted at the beginning, but I want to mention it again. We do have another seminar coming up. It's going to be in person June 23rd at the David Whitney Building, Aloft, Detroit, Michigan, with a reception and an outing at a Tigers game to follow. So be on the lookout for that, but go ahead and save the date now. Mark that off your schedules. And like I said, a formal registration will be going out soon.
And we have a block of tickets with the Tigers, so we need to get people to go to that Tigers game. It'll be fun. They're playing, I think,
Minnesota Twins.
Is that who it is? Okay.
Yep. All right, guys. Thanks a lot.
All right, guys.
Thank you.